Hello, everyone. This is Howard Kline, and you are listening or watching the Resolve This podcast. In this podcast, my guest and I, David Reif, I always have
Reif.
trouble with your name, Dave. Reif. We'll
And
be
now
the
it's right. It's Reif. It's a
Reif.
long I. Rhymes with strife.
Yeah, yeah. I'm sorry, David, and I always mess it up. We'll write that off to my medical issues. In any event, we will be discussing two recent cases before SCOTUS, which is an abbreviation of the U.S. Supreme Court. And the first case has to do with what happens when a court declines to compel arbitration. We'll refer that to the Coinbase case, which had been decided last year, and then there's a new version of it that's going to be argued in next week. And was it next week or this week?
It's this Wednesday, this coming Wednesday, day after
This
tomorrow.
coming Wednesday, day after tomorrow. So I'm going to try to get this out sooner rather than later, but it might be difficult. And the second case I find particularly interesting is called Bissonnette versus LePage Bakeries, which was recently argued before SCOTUS, and it has to do with forced arbitration, which is a phrase that I find interesting, and various questions involving the Federal Arbitration Act and an exception to the enforcement of an arbitration provision relating to interstate or intrastate commerce. I am not doing it justice by this introduction. Very quickly, David is an attorney with over 4 decades of litigation experience and is currently a full-time mediator, arbitrator, and what we refer to as a neutral. He has considerable experience involving franchising, unfair competition, and non-competition agreements. Because I like to get into the topic of the podcast quickly, the rest of David's considerable experience will be provided in written form where you access the video or audio version of this podcast. Me, just quickly, I've been an attorney. I'm going to beat you with decades of experience, David, because I started in 76. So if we're going from 71 until 80, I've got more decades of experience. I don't have as many jury trials as you do, but I've been practicing law as a California licensed attorney since 1976. And I am currently a full-time mediator and arbitrator. And recently, I am on the panel. I forgot exactly how they want me to do it, as both an arbitrator and mediator with the American Arbitration Association. And I'm very proud of that. So let's start. Yeah, I just, was it 2 weeks ago? Finally got my mandatory training, which frankly was very good. It was in Miami. I'm now there and waiting to start getting assignments from there. Let's talk about Coinbase.
Sure.
I'll let you go ahead and start the description of Coinbase, and then I'll interrupt you freely since this is my podcast.
Fair enough. And that makes it a lot more interesting.
Yeah.
First of all, thanks for the invitation to be on with you. I follow your podcast on LinkedIn and elsewhere, and I've got to tell you, it's terrific.
Well,
So I really
thank you.
appreciate the opportunity. Let me start with the current Coinbase case, which is going to be argued. We're recording this on Monday. It's going to be argued on Wednesday. It's a weird case. And it's one of these ones where I think that the justices have got to be are going to be asking themselves, what are we doing here in this? I don't think they'll go so far as to issue what's called a dig, which is a dismissal on the basis that cert is improvidently granted, but they really are the issues. They're largely going to be deciding them as if they were the California State Supreme Court, because this one really breaks down to is a question of state law. little bit of background. I don't know if you remember Dogecoin. Dogecoin back in the early days of cryptocurrency was this, a couple guys actually came up with it almost as a joke. It was a Bitcoin with a picture of a dog on it, and they called it Dogecoin. And they originally went on the market for a penny. And Coinbase is one of the largest, if not the largest, cryptocurrency exchanges out there. And they wanted to start to carry Dogecoin. They ran a sweepstakes. And the sweepstakes was if you bought $100 worth of Dogecoin, you then went into the sweepstakes. Two different documents involved, and that's where this thing really comes in. When you logged on to set up your account, your original account, there was a user agreement. The user agreement had a broad arbitration clause. It had a delegation clause. And what a delegation clause is a part of the arbitration provision, which says that questions of arbitrability, the scope of the arbitration clause, those kinds of issues, unconscionability, those kinds of issues will be decided to the arbitrator. Normally, those issues that are called threshold issues or gateway issues, depending on who's writing the opinion, are for the court. The parties can, by what the courts call unmistakable and clear language, delegate those to the arbitrator. So that's the first agreement. Then if you went into the sweepstakes, you ended up also signing on to the official rules, they called them, of the sweepstakes.
Let me interrupt you again.
Sure.
This was the first interruption. Just quickly, for those uninitiated with cryptocurrency, Coinbase is basically an online repository of digital currency.
I think that's essentially it, and it is the place where you buy and sell.
Right.
Blockchain is beyond this political science majors can, but essentially blockchain provides a way in which you have a locked way of recording ownership. And as I
let me explain it to you. As a litigator, you'll get this because I was actually asked to speak at a blockchain event, and I'm going, why am I here? I have no idea what's blockchain. And as I listen to people, it's simply a way of authenticating something.
Right.
As an attorney who handles litigation, we're constantly dealing with, is that document really what it says it is?
Yep.
All right. And we, as attorneys prior to blockchain, we relied upon a lot of different methods to authenticate testimony, etc., handwriting recognition, a number of different ways. So with blockchain is a computerized algorithm that is so complicated that it can, with a considerable amount of reliability, authenticate something, whether it's a person, whether it's a document, etc. And most normal human beings really don't need to understand it.
Right.
Yeah, we don't understand it because it operates generally in the background.
Yep.
It's like
my car. I'll be darned if I can ever understand the internal combustion engine. All I care about is when I turn the key on, the thing revs up.
Absolutely. Now that I've interrupted you and probably have gotten you totally off track, why don't we get back to what you were talking about?
So where we were was we were talking about the fact that there's two agreements. There's a user agreement, which has a broad arbitration clause, which I think everybody agrees would cover the actual underlying dispute, and has a delegation clause. If you went into the sweepstakes, you entered into a user agreement. User agreement does not have delegation and as if any arbitration far more limited. So what the case is it is a class action brought by a group of people, all these four who are involved, all of whom entered into the agreement by signing on, buying $100 worth of crypto, and therefore coming into the sweepstakes. They executed the user agreement. They executed the official rules. They brought an action claiming that the contest violated certain rules related to sweepstakes in California. And Coinbase then has come in and they said, wait a minute, this needs to be arbitrated because of your agreement to arbitration under the user agreement. District court said no, that the second agreement is the one that is binding, the official rules. That does not have an arbitration clause, therefore no arbitration. Went up to the Ninth Circuit. Ninth Circuit said the same thing. They said no arbitration because this is a question of contract formation, not a question of the scope. So let me run that a little bit. The case law is consistent that you cannot delegate questions of contract formation. Let me go back to the why, and I'll go back 57.
When you say delegation, you're talking about delegation of arbitrability.
The delegation of issues as to whether it's arbitrable. You and I enter into an agreement. We say that these particular issues that the court would normally resolve are going to be resolved by the arbitrator. The one where you really can't do that logically is the question of whether the parties ever entered into an agreement. I will go back to in explaining that, I'll go back to my first year contracts professor, who used to say, ex nihilo nihil fit. Nothing comes from nothing comes nothing. And where that fits in here is that if we've never entered into an agreement, therefore we've never entered into an agreement to delegate any of these decisions. What the Ninth Circuit said is that, and that doctrine of whether we've entered into an agreement, the jargon is contract formation, and you look to state law as to whether the parties have formed a contract. Ninth Circuit said this is a question of contract formation and therefore not delegated. Everybody agrees whether they think that the result that the Ninth Circuit reached was right. And the Ninth Circuit then said, oh, and by the way, looking at it, we determined that there's no arbitration. The issue, everybody agrees in the briefs that the Ninth Circuit got it wrong in terms of what they called it. Everybody agrees this is not a question of contract formation. They formed a contract. They, in fact, arguably formed two contracts, a user agreement and official rules. The real question, and this is laid out probably if anybody wants to go back and read something, probably the best thing to read to understand where the real distinction comes is an amicus brief that was filed by 4 law professors at the very end. You can, just as background, you can get all the briefs, you can get the petitions from this wonderful source called SCOTUS blog. If you don't know SCOTUS blog, go to it. It was formed way back when by Tom Goldstein, and it has literally all the filings on all the Supreme Court cases. And you just click, there's a hyperlink. So if you want to see a brief, you go to their drop-down cases, you'll see the case, you click on it, and you've got the whole thing. So what the professors say is that as a matter of contract law, the official rules, the second document, constitutes a novation of the first agreement. And since it does not have a delegation clause, there's no delegation. Ex nihilo nihil fit. The user agreement doesn't count anymore. The official rules do. So what this really comes down to when you read the briefs is a question of state contract law. What is the effect of the user agreement? Now, I would argue that Coinbase finesses that. Coinbase relies upon the doctrine of delegation. And years ago, the Supreme Court decided a case called Rent-A-Center. And what Rent-A-Center says is that if you're going to attack a delegation clause, you've got to attack the delegation clause. Think of it like the Russian dolls that we all know, where you unpack a doll and there's a doll, you unpack a doll, there's a doll, you unpack a doll, it's a doll. So what Rent-A-Center says is that if you want to attack the third doll in the delegation clause, you can't attack the big doll. You got to pull the delegation clause, you got to pull the arbitration clause out of the big doll. And so you basically have a mini determination as to unconscionability or applicability. You then have to pull the delegation clause doll out of the arbitration clause doll and look at just that. And what Coinbase argues here is that the user agreement delegates issues to the arbitrator, and if you're going to attack that, you've got to attack that delegation clause. And that really this is a case of arbitrability. They characterize the question as, is the applicability of the user agreement, of the official rules, does that in some way, how does that fit into the user agreement? What the plaintiffs say is no. You're looking at it from the wrong end of the telescope. Where you really have to look at it are the official rules a novation of the original agreement? Because if so, then the delegation clause no longer really exists and we can ignore that. All of that comes down to state law. So SCOTUS has got to be sitting there saying, do we really want to get involved in deciding supreme question of the applicability of the novation provisions of California state law? I think they're stuck a little bit with this case because when they took it on, I think it was clear to them that the Ninth Circuit's way of getting there was wrong, that this is not a contract formation question. But it's really a contract interpretation question, but you've got to look at whether that second agreement ever became effective or not. I suspect the Supreme Court feels a little bit like you do when you accept a dinner with your boss that you know you have to do, but you don't really want to be there. And I think that's probably, I would suspect that's probably where at least a lot of the justices feel they are right now. We have taken this case. We had to take it because the Ninth Circuit got there in the wrong way. But having the parties agree on that, we really don't want to be here.
Let me step back a second for those people who may be listening or watching who are not lawyers. So there's the issue of whether or not this was a novation, and that issue arguably is an issue of California law.
Right.
If it's not an ovation, What might it have been? And from my perspective, I'm going, maybe it was an amendment that may have incorporated the earlier click wrap agreement, in which case the delegation might be effective. Now, normally, what we do when we create an amendment, there's usually a provision that says, except as specifically contrary as said, the terms of this amendment will be the prevailing terms, except but will otherwise, where it doesn't specifically contradict, will incorporate the earlier agreement. And I don't know what the user agreement provided, probably didn't provide that. Otherwise, it would have been a simpler matter. But often in state court, particularly in California, if you can't really tell whether or not it was an ovation or amendment, the court would first look to what the parties intended, which is a trial court issue.
But it's a trial court. It's a trial court issue. It is a trial court issue that gets decided as a matter of law. But the problem that we've got here, A, you're right. It does not talk about this merely being a modification. B, you're right that the argument from Coinbase is that that's really all that did. The argument on the other side is it is wholly self-contained. The argument that the official rules are wholly self-contained, and that they include a forum selection clause that talks about enforcing it through the courts of California. There's all kinds of law out there that we really don't need to go into, where what the effect is when you have a forum selection clause and you have an arbitration agreement. And the law, I think
I'm assuming that the trial
exclusively.
Yeah, I'm assuming that the trial court never got to take evidence on that issue.
They didn't, because they say this is contract formation. That's right.
It's contract formation. The court denied the motion to compel, correct?
Correct.
And then we're back where we are, which then raises the issue of what the earlier Coinbase case was about.
Sure. Well, the earlier Coinbase case, which was decided last year, was this case, the current one, is really going to be off there. And it's going to be interesting to see how interested the Supreme Court really is, because if you look at the rest of their docket this week, this is the last case that's getting argued on Wednesday before they break until something like March 18th. Today, they're hearing the internet free speech cases, and that is whether a state can limit what is on the internet. Tomorrow, they're hearing a question as to forfeiture, criminal forfeiture, which in the current environment is a pretty big deal. The other case they're hearing on Wednesday, and it's interesting, as somebody who is in Las Vegas, you'll probably be particularly interested in that, is the question of whether a bump stock turns a weapon into a machine gun under federal prohibitions. And then after that week, they're then going to deal with this last.
Let's talk about the original, last year's Coinbase.
Yeah, let me just say one thing before that. If anybody who is interested in appellate argument still should listen to the Supreme Court's arguments on Wednesday. They record them all. You can get them in two ways. You can get them as a transcript on their site, or you can get it as an audio. If you want to hear good appellate advocacy, listen to the argument. Neil Katyal, who people who follow TV news have probably seen, who also is professor at Georgetown Law School and has argued 50 cases in front of the Supreme Court, including 10% of last term's docket, the 2022-23 docket, is going to be arguing this. And so if somebody really wants to hear, and they're recorded, so you can go back to them. If somebody really wants to hear appellate advocacy, this is probably a case that you want to hear, despite the issue. Turning to last year, Caddy also argued Coinbase last year. Coinbase last year is a big deal. The issue last year is called Bielski versus Coinbase. It's one of the other plaintiffs. And what happened in that case is that Coinbase there also filed a motion to compel arbitration. That was denied. Under the Federal Arbitration Act, while you cannot appeal from the granting of a motion to compel arbitration, you can appeal from the denial of a motion to compel arbitration. Here, the motion was denied, and Coinbase took an appeal to the Ninth Circuit. In the course of that, they filed a motion in the trial court while that appeal was pending. And the appeal, by the way, was just resolved in December of this year. While the appeal was pending, they filed a motion to stay discovery. The district court denied that motion. They then took an appeal of that stay request under, I think it's 1292. They took an interim appeal because you can appeal the denial of an injunction. They then took an appeal to the Ninth Circuit. Ninth Circuit also said, no, we're not going to stay discovery. So you've now got a situation where Coinbase has appealed the denial of the motion to compel, but they also have to go through discovery in the underlying discovery and motion practice. They now need to fully be litigating the underlying litigation. At the same time, they're saying we shouldn't have to litigate this because it's arbitrary. What the Supreme Court did last spring, in June, in a 5-4 decision, overturned the Ninth Circuit and said during the period of time that the appellate court is considering a motion to compel, the denial of a motion to compel arbitration, the rest of the case stops. 5-4 decision.
It's a mandatory stay.
It's a mandatory stay.
Versus how the district court and the Ninth Circuit, they took the position that it was discretionary.
That's exactly right. And the Supreme Court has said it's mandatory. And it is, frankly, the 5-4 decision splits while they talk about language of the statute and all that. It is really very much a policy-oriented split. The majority says it is a waste of the court's resources, the parties' resources, and contrary to the whole concept of arbitration being cheaper and faster, to require the parties to go through all the expense and the court to go through all the time deciding procedural motions to dismiss and all those kinds of things, when it in fact may become mooted by the reversal on the denial of the motion to compel. Because if it goes to arbitration, none of that stuff happens. The three dissenters I think it's Justice Jackson, who, it's either Jackson or Sotomayor, I think, who wrote the dissent, say, look, we're looking at it from the other end. what is the effect on the plaintiff to put this case on hold for, I think it was about a couple years, or about a year, while the Court of Appeals decides whether the trial court was right. And one of them specifically talks about, what about witnesses who die? For example, and if you stop and think about that, if you're dealing with healthcare cases where you have somebody in extremis who a witness or a party whom you're not going to be able to depose because of this mandatory stay. So it was really a very outcome-driven decision. But the bottom line is that Coinbase could not be clearer that where you're dealing with the appeal from a denial of a motion to compel arbitration, the case screeches to a stop. Raises some interesting issues. We're lawyers. What is it that you do? Because I'm not about to sit there and say, hey, look, my hands are tied. So I think there's some things you can do. A couple of them are very much driven by your trial court judge and where he or she falls on the plaintiff defendant side. One of them is, remember what it is that triggers the mandatory stay. And that's an appeal from the denial of the motion to compel. So rule one, get in there, get your discovery done right away, and get the court to defer.
You're talking about the
underlying case.
I get, yeah.
If
I
I'm
can
the
understand, yeah. Just give me a minute here. Sure. Because you have to understand, it's not just lawyers who will be listening to this; it'll be non-lawyers.
Okay.
And so, what you're suggesting is, if you're a party that doesn't want the matter to be arbitrated, get your discovery in right away.
That's right. If there's some discovery, even more than that, if I'm the plaintiff, the party that does not want arbitration, and I'm worried that over the next 12 months, there's going to be people that die, there's going to be documents that are lost, I want to get my discovery done, what I would suggest is start your discovery right away.
What I always did when I represented the plaintiff.
And try to convince the judge to defer informally a decision on the motion to compel as long as he or she can or will, so that I can get a deposition done, so I can get testimony taken, so I can get documents, so I can do whatever I need. So that's number one. That requires a plaintiff-friendly judge. Number two is that, and a part of that, there's a thing for non-lawyers, there's a thing called request to produce documents, where I say to you, give me documents. The time for replying to that runs from the time I serve them. There's a little caveat, there's a conference that's got to happen. But again, that's the kind of thing that happens early on. The third one, and this really is in the weeds lawyer, and I don't know how to move it out of there. There are a set of rules, the federal rules of appellate procedure, and that governs what are the rules for an appeals court. So when you take an appeal from the denial of the motion to compel, you go to the Court of Appeals. Those appeals courts have a separate set of rules. One of those rules says that the appeals court can keep the case, but bounce it back to the trial court for a limited purpose. If the trial court says this limited purpose is important. So, and the other thing I would clearly do is if I had a witness who might be dying, I would go to the trial judge and say, hey, judge, I want to take this appeal. I want to take this deposition. This person may not be or is not going to be around in a year. Documented, doctor's reports, all that stuff. What I want you to do is certify this as an important question. Then I go to the appeals court and I say, hey, look, bounce this back to the trial court just for me to take that one deposition. I think under Coinbase you can do that, because what Coinbase says is once it goes to the Court of Appeals, it's in the Court of Appeals. That's why the district court can't do anything. So I go to, where did you tell me it is now? You're now telling me it's sitting with the Court of Appeals. So I'm going to go to the Court of Appeals and say, send it back for this limited purpose. I think it works.
Yeah, that's interesting if you do it that way. And I have a couple of other comments. Is what you're then saying is the Court of Appeal then has discretion.
That's right.
Which is exactly what the Supreme Court said it doesn't have.
No. The Supreme Court said that the district court does not have discretion. It doesn't. What the Court of Appeals says, remember what a Court of Appeals does for folks that aren't lawyers. Court of Appeals reviews what the district court did. What the Court of Appeals says is that the district court, assuming it had discretion, correctly exercised that discretion. What the Supreme Court said is that once it goes to the Court of Appeals, the district court can't do anything. So what I'm proposing is that you go to the Court of Appeals and you say to the Court of Appeals, hey, Court of Appeals, send it back for that limited purpose. Does it work? I don't know. But
this is what I'm suggesting, is that the effectiveness. So the last year's Coinbase case says it's not, as you say, the district court, the trial court, does not have discretion to either stay the case or not. It's mandatory.
Right.
And effectively, the appellate court can say they did it correctly, but we're now going to send this stuff back and say the stay is effective unless we say that it's not, which what you're suggesting is that the appellate court then has the discretion to stay or not, which raises another whole practical issue. The thought crosses my mind that, and for those who are not familiar, you can do discovery in arbitration.
Right.
So when I look at it is, okay, the district court, the trial court has decided it doesn't have discretion. You can't move forward while the decision on whether or not this is arbitrable or not, that all becomes, everything is state, everything. And I'm not sure is the practicality of that, and whether or not that even makes any sense without at least looking into whether or not there is an opportunity or an intent to do discovery and arbitration. So I think it becomes even more efficient if you go on the issue of discovery, saying, why wait a year to have this issue of arbitrability determined by the appellate court, or a year and a half by the time you're done? Why don't you just go ahead and do discovery, and what difference does it make if it's in under the guise of the trial court versus in arbitration. If
I,
you're going to do discovery, you're going to do discovery.
and I think that's the very practical trial lawyer answer. The problem is the problem is that I don't think Coinbase lets you do that. Parties can always do discovery. We can always agree, hey, look, and if you've got reasonable counsel, you probably would. Look, Millie Glutz is a crucial witness in this case. She's not going to be around in a year. Let's agree that we can take that deposition.
But the parties
Depending
can
on
always,
who Millie Glutz is.
the parties can always do that.
Sure, but if
the issue is whether or not one party wants to do it or not. Right. And in this particular case, Coinbase is going, no, let's arbitrate the matter first, and let's delay everything, including discovery, which becomes then, in any event, a likely burden on the plaintiffs who are looking to resolve the dispute as quickly as possible, while Coinbase is looking to delay. And I think it gives at least with regard to discovery, if you're going to do discovery, just let the parties do it, even when one party doesn't want to do it, because I don't see the prejudice.
You sound exactly like Justice Jackson. Unfortunately,
I don't see the.
Unfortunately, Justice Jackson was in the minority. You've just written a terrific dissent, but the problem is that it's a dissent. I think your question, though, if we back up to, can the appellate court do what I said I think the appellate court could do? And you said the Supreme Court says they can't. The doctrinal underpinning of what the Supreme Court did is a case called Griggs. And what Griggs says is that once a case moves from the district court to the appellate court, everything that is their term, the Griggs term, integral to what is now before the Supreme Court, before the appellate court, leaves the district court. And the Supreme Court says everything having to do with the arbitration is integral. So what does that mean? It doesn't mean that the appellate court can't do something. It means, as I would read it, that only the appellate court can do it. Rule 12 of the appellate rules, which is shift back for a limited purpose. So if I were a plaintiff in that case, that's what I would be doing. I'd be making an application. I would be making an application to the Supreme, to the Ninth Circuit. Now, all of that may become moot because Bielski, the Ninth Circuit in December decided that Bielski, in fact, should be arbitrated and that the district court was wrong in its underlying motion. So it's now going to go back. It's now going to go to arbitration. And so all of this in the real world of the Bielski case becomes pretty moot. But in the real world of the rest of the lawyers who are banging around, particularly the plaintiff's bar, it is not only it is not moot. It is, in fact, a real albatross around their neck.
Sure. And I look at it being predominantly in litigation, a plaintiff's lawyer. I look at it as just causing delay. Effectively, it just causes delay.
I think it does.
Of course, it does more than that. But as a trial lawyer, that's its effect upon me and my client. It's like I want to, as a plaintiff's trial lawyer, I want to get moving. I want a remedy, whether it's some sort of interim award or a payment of money or whatever. I want this thing moving as quickly as possible. And the defendant tends to want to delay. In some cases, if you deal with an attorney who's more of a collaborative lawyer on the defense side, they're looking to resolve things in the best fashion possible for their client. And sometimes, and that does not necessarily mean delay.
Right.
All right. So
I think you're absolutely right that delay is one issue. I think the other issue is that the scope of discovery is far more limited generally, or at least there is a risk that it's going to be far more limited in an arbitration than it is under the federal rules. And if I'm a plaintiff's lawyer, not only am I worried about delay, I'm also worried that I have an arbitrator who leans more on the fast and efficient part of the rules than he or she does on the full opportunity to present a defense.
that's a good point. That's a good point because, again, the arbitrator has a little bit more discretion in terms of what kind of discovery can or cannot do. And there also may be limitations with regard to third party discovery
Right.
in arbitrations where it's easier in state court to get some sort of enforceable order against a third party.
That's right. Yep.
Okay, so we're 46 minutes into this.
All right.
And I really wanted to get to Bissonnette, but
Sure.
I've got a hard stop. And I was only planning on doing about a half hour. I'm somewhat reluctant, though. Well, let's give
you 14 minutes.
Let's give us as much as we can if I can stretch it, because
Sure.
I don't want to. You and I have had such a difficult time sitting down and getting this taken care of. I really would like to talk about Bissonnette.
Sure. Sure. Let me talk about Bissonnette. It was argued last week, and the argument again, transcript is available on the SCOTUS on the Supreme Court's docket. Here's the background on Bissonnette. Bissonnette comes out of Connecticut. It is the Wonder Bread distributors, but it's not only Wonder Bread; it's cupcakes and all those kinds of things. And the way Wonder Bread has things organized is basically as a franchise. Their delivery guys. This is how Archway Cookie did it. This is basically the way that the baked goods industry works. I buy a territory. I enter into an agreement with Wonder Bread, LePage Bakeries, saying that I now have a particular territory, and I can buy and sell that territory. But I now have this territory. I pick up the bread at a warehouse in my own trucks, and I may have other folks that work for me in my own trucks, and I then deliver that to the stores. And the general model is that I sell it to the stores. I essentially buy it at wholesale, sell it at retail, and I pocket the VIG. And so the difference. And so the issue, and this is one of those cases that, and there's a lot of them, wage and hours. Am I really an employee? Am I really an independent contractor? And so the question becomes, are these drivers workers in interstate transportation? And let me tell you why that becomes relevant. LePage drivers bring a lawsuit. Well, I'm not going to characterize it. The people who distribute bring a lawsuit. LePage says, hey, look, your agreement with us, and they all have individual written agreements, requires arbitration. we want the U.S. District Court to compel arbitration. Now, you got to get a little wonky. The Federal Arbitration Act, Section 1 of the Federal Arbitration Act, is what gives the district courts the power to enforce arbitration agreements. It's got a carve out, and the carve out is seamen, railroad workers, and other workers in interstate commerce. The argument, these guys clearly aren't railway workers. They're clearly not seamen. The question is, are they other workers in interstate commerce? Now, the Supreme Court has said that you've got to have some tie with interstate commerce. So if you are a desk clerk at, a desk clerk at LePage Bakeries, you are not a worker in interstate commerce. So the exception doesn't apply. But the question is, what is it if you pick up goods, you put goods on your truck that have come from Massachusetts in this case, you pick them up, you deliver them, the bread is certainly in interstate commerce, made in Massachusetts, delivered in Connecticut. You are certainly a part of that, but are you a worker in interstate commerce? And where it comes down to the two different views, the plaintiffs claim that the industry has to be in interstate commerce. The defendants argue that no, it depends on, or it's the other way, that depends on the worker. What the Court of Appeals and the district court said is, hey, look, LePage is not a business in interstate commerce. I'm not buying transportation. If I have a grocery store and I say, hey, load up my shelves with Wonder Bread, I care about that it's the bread. I don't care about how you get it to me. That's not, that's a minimal part of my work. The plaintiffs say, no, you look to the worker. And these guys and women that are involved in this spend 30% of their time driving trucks and stocking shelves, and only 20% of their time doing paperwork and the other parts of running a business. So there's
an important thing. There are two important things here. One of which is that, and I don't know if you've made this clear, the franchisee is not crossing state lines.
The franchisee is not crossing state lines.
Yeah, so the employee and the employee and the franchisee are exclusively within a state. It's intrastate commerce.
That's right.
Versus interstate commerce. But then I think you raised the point: is the business of shipping from, even if the plaintiff or the petitioner is not crossing state lines, the product is. And
that's exactly
the
right.
The general scheme is that the whole thing falls within interstate commerce. And they go back to a couple of other cases, one of which is Southwest. But again, I think it can be distinguished from Southwest because in Southwest Airlines was involved in interstate commerce, and that the employee themselves who were packing and unpacking luggage, while they may not have been physically crossing state lines, certainly Southwest Airlines was involved in interstate commerce.
And everybody cites to, in their briefs, not in their oral argument, interestingly, but in their briefs, they cite to Saxon. And yes, because there is language in Saxon that specifically says, we don't look to the worker, or we look to the worker, we don't look to the industry. And then that language is in there. What the plaintiffs say is, hey, look, you really, what the parties who are distinguishing Saxon say is, look, everybody just assumed that it was a transportation company. It's an airline. So the question then, the interesting issue is not just bread guys. It's where does this play out more largely? So where does it play out for the person, the classic, we call them last mile. So it is the person who works for FedEx or Amazon who delivers the last mile, who gets it from the local warehouse to my house. In the oral arguments, that really, everybody ducked that. And in fact, Justice Sotomayor specifically ducked it and said, we can leave that for another day. And that's not in front of us. Because let's think about the consequences of that. If you look to the industry rather than the worker, you end up with a difference between UPS and Amazon, because UPS clearly is just delivering goods. I pick up, I go to, in my case, I go to my coffee place, the one that sells the little things that go in the machine, San Francisco Bay Coffee. I go on the website, I order from San Francisco Bay Coffee. The guy in the brown uniform from UPS puts it on my door. The only thing that UPS is doing is transporting. I go online with Amazon and I buy a blanket that was made in China. The Amazon driver may deliver that to me. Or if it is a little item, the US Post Office is going to deliver that to me and put it in my mailbox. From the Amazon point of view, they are not a transportation company. And in fact, in this case, Amazon filed an amicus brief in which Amazon specifically says that. The interesting thing will not only be to see what the decision is. Do you look to the worker or do you look to the industry? And if you look to either way, how do they then define the worker? How does SCOTUS then, because part of their job is to draw lines, how do they draw the line on the worker or the industry? Interestingly, in December, the Supreme Court has already sent out 2 petitions for cert, and they've distributed them for conference, and they've been sitting since January. One of them is a case called Amazon versus Miller, which is a last mile driver. And is a last mile driver covered by the FAA? Supreme Court has not decided whether to grant cert in that, and I am sure they are waiting to see what they do here. The other one is a case called Domino's Pizza versus Carmora. And what that case is, the guy who picks up the dough at the warehouse and delivers it to the franchisee. So he is something, but he is I think he is an employee of Domino's Pizza. So he falls somewhere in between. Both of those cases have petitions for cert pending. But if you read the transcript, or when you read the transcript, if you're interested, of the oral arguments, and they make it very clear. What the arguments go back to is the original language of the FAA, where they say, as I said at the beginning, seamen, railway workers, and other workers in interstate commerce. At the same time that this statute was brought in, there was already arbitration for seamen under a different act. There was already arbitration for railway workers under the Railway Act. And so the argument is, hey, look, it's got to be very much like they did not intend to include people like this. What they intended to do was to carve these people out because they already had arbitration. And when they used the language other workers, they were trying to be proactive. So for example, airplane pilots. Airplane pilots are, interestingly, airplane pilots are covered by the Railway Arbitration Act. And back when they did this, they didn't contemplate airplane pilots, but the argument is that other workers in interstate commerce was intended to mean people who were going to fall under these other statutes. This is a big case. It will be interesting to see where this splits out. In reading the arguments, you really cannot tell where people are going to come down. It's not the clear split that you have in Coinbase 1. But what is clear is they got no intention of walking into the Amazon thicket in this decision. If they do that, I will be very, very surprised, because they ducked that one like crazy.
Great. We're going to wrap this up, and I'll be able to squeeze this into 1 hour. And I'll probably write a little bit more about Bissonnette, because my perspective, and this is interesting, your perspective is based upon your background. So you look at this not only from the perspective as a lawyer, but one who is very familiar with franchise agreements. So you see it through that lens. I've been general counsel for a supermarket chain that had many labor unions and collective bargaining agreements, and familiar with efforts to avoid the obligations of collective bargaining agreements and efforts by the unions to enforce what they believe to be the obligations of collective bargaining agreements. And I look at this a little bit more from the trial attorney perspective of, wait a second, LePage Bakeries required the truck drivers to form a corporation. And I asked the question, why would they require the formation of a corporation, even if there was a single driver? It was an individual basically an individual franchisee. Why would they require that interim or mitigating factor between the actual driver, Bissonnette, which Bissonnette in essence tries to ignore the corporate entity? And I asked the question, why did they require it? And I didn't read anything that explained why they required the formation of a corporation. So perhaps, based upon my experience, I'm drawing the conclusion that they were looking to have a further separation between the individual driver and LePage Bakeries.
Absolutely. There's no question. And generally, franchise operate through a separate entity. I think one of the other reasons may be that I think the big one is to add additional separation. The benefit for the person with the root is that they then can add some family members. There's some restrictions on whom they can bring in, but from their point of view, it also allows them a little bit more flexibility. But I don't think there's any question that a part of it is to put in one more separator, so that because remember, there's other reasons you don't want people to be employees. I mean, you don't want people to be employees because of workers' comp reasons. You don't want people to be employees because of overtime reasons. You don't want people to be employees because of reimbursement issues, all of which are the merits of this litigation.
But what I'm suggesting here is this: being an employee of LePage Bakeries is one thing. Being an employee of that separate corporation where you're in essence a sole proprietor, because they didn't explain it, but franchise, from my perspective, franchises can be multiple locations, can multiple regions, and have multiple employees. Where the impression I got from this case was that there was at least a substantial amount of individual truck drivers whose franchise was really just they were either the only truck driver. And I got that impression. Whether or not that's true or not, I'm not really sure, but I'm going, okay, if you want this region, you want this franchise, and it's going to be X amount of square miles, you can do whatever you want, but instead of you being an employee of LePage or us having a franchise agreement with you, the individual, we're going to have a franchise agreement with this corporation. And even if there's only a single driver. And I think that also excludes having a bookkeeper. You don't have to get an independent bookkeeper. You can have an employee for this corporation.
Right.
And not fall within the exclusion to the FAA, arguably, et cetera. I don't know. From my perspective on this, because of my background, I'm thinking in terms of, well, they talk about Bissonnette and the petitioners all as if there was no corporation in the interim. And I always think in terms of that corporation is a corporation, it's a separate entity, and as a plaintiff, I'm trying to collect, which is where most of my litigation is. I'm looking at whether or not I can pierce that corporate veil. And in this case, it seems that it's just taken for granted.
The plaintiffs in this case are the individuals. I mean,
Right.
and that's why it's taken.
They're not the corporations.
I mean, the plaintiffs essentially argue, hey, look, any intermediate entity is basically irrelevant. We are, right, in fact, and that's the reason that it gets ignored. Their whole argument is we are really employees, functionally employees. It's the old ABC test that the NLRB uses.
Yeah, I just didn't feel that was argued quite as much. It was just taken, to me, it was almost taken for granted, where in this particular case, the arbitration provision is between the corporation and LePage Bakeries. It's not between LePage Bakeries and the individual.
Interesting.
And I just didn't see that position taken, certainly by LePage, quite as much as I would have liked to have seen.
Yeah, I think that's a good issue, and it's one that didn't get raised.
It may be diplomatic.
It may be in part that it didn't get raised because LePage doesn't want to deal with that now. They think they have a better chance of dealing with that in front of the arbitrator, and so that may be part of it. Part of it may have been a strategic decision.
Don't know. In any event, I'd like to thank you very much.
Thank you.
My pleasure. To get this out and see if I can get this recording within an hour. and I will let you know when it becomes available.
And let me know
I'm
when it
so
becomes
glad.
available, because I would love to go on LinkedIn and elsewhere and let people know about the terrific work you're doing. So thank you.
Great. Thank you very much. And I'll speak to you later, David. You take
Sounds
care.
good. Take care.
Bye bye.
Bye bye.